Welcome to immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello everyone, edition webinar hosted by immigration.com, a network platform and meeting ground where immigrants, families, advocates, and licensed immigration attorneys come together to understand U.S. immigration policies and procedures better. I'm GB Satusa, your host for today's important discussion, employment-based green cards, understanding delays, and how to plan ahead. Now, in today's immigration environment, many professionals, employers, and families are experiencing significant delays in employment-based green card processing. These delays can create uncertainty for individuals planning their long-term future in the United States, particularly when it comes to career growth, travel, and family stability. Now, for many applicants, understanding the reasons behind these delays and how to plan is not just helpful, it can be essential. Strategic preparation, awareness of processing times, and proper case management can play a critical role in navigating the system effectively and avoiding unnecessary setbacks. To help us break this down, we're honored to be joined by Attorney Jacob Tuimaualuga. I hope I said it correctly, attorney, a Utah-based immigration attorney with extensive experience guiding businesses, investors, families, and individuals through the complexities of the U.S. immigration system. He combines strategic insight with practical solutions to help clients achieve their immigration goals. Attorney Jacob, thank you so much for joining us today. We're thrilled to have you for this important discussion.
Thanks for having me, Blessing. Appreciate it.
Now, before we begin, a quick reminder to our audience, immigrationquestion.com is a public educational and networking platform. The information shared today is for general informational purposes only and does not constitute individualized legal advice. If you're joining us on Facebook, LinkedIn, YouTube, or any other platform, welcome. Please subscribe and share this session with anyone who may benefit from understanding employment-based green card delays and planning strategies. All right, let's dive right in. Attorney Jacob, what are the main factors currently causing delays in employment-based green card processing?
Oh, man. Really, the delays are twofold. One are the procedural delays that are caused, frankly, transparently by the Trump administration's policies. And then second are the country-specific caps just associated with employment-based immigration. So unlike marriage-based green cards where there's essentially no limit to how many you can do a year, employment-based has a set number of visas that they are allowed to issue each year under those categories. And pretty much every year those caps are met. These caps are particularly full for applicants from China or India, and that's why there's such long processing times there. Even notwithstanding those caps, though, there have been policies set in place by the Trump administration, including visa freezes and other immigrant visa pauses that have just made processes take longer than they have in times past.
Yeah. So how do visa bulletin backlogs and priority dates impact applicants waiting for their green cards?
Big time. Yeah, that's really, I don't think I can understate how long or how big of an impact these have. So for those of you who may not be familiar, the visa bulletin just lists the priority dates for when USCIS is processing or the State Department processes your petition. So when you file an I-130 or an I-140 petition or an I-360, you get something called a priority date that's listed on your receipt notice. And until that is listed on the bulletin, your visa or your green card can't get processed yet. So the longer away that date is on the bulletin, like if you're, for example, if you are from Mexico and you have a brother or sister who's an American citizen and they filed for you, they could have done that 20 years ago and it's still maybe way far away because the date on the bulletin is probably in 2006 or 8 right now, right? So that's what those delays mean.
All right. Now, what steps can employers and employees take early on in the process to better prepare for potential delays?
The biggest way is just to make sure you maintain your non-immigrant or your temporary status until your green card is ready to process, your immigrant visa is ready to process. If not, the next plan should be to leave the US and to begin processing that immigrant visa outside the country. This is really common for those who have L visas here in the States, particularly for those from China or India that just have longer waiting times than most other countries do.
Now, how important is it to maintain valid non-immigrant status while waiting for a green card? And what risks should applicants be aware of?
It would be incredibly important to maintain your temporary status here. There's basically only two exceptions, popular exceptions to this. Number one, if you're applying based on marriage to a US citizen or your child is a US citizen who's over 21, then if you haven't maintained your status, it's still possible for you to get your green card here in the States. If you're applying based on employment visa, which is what we're talking about today, you only have about 180-day forgiveness window, assuming you have your I-140 petition approved. So if you want your green card here in the States, you got to make sure that you maintain that non-immigrant status.
Yeah. Are there strategies that applicants can use to minimize disruptions to their work authorization or travel plans during the long processing periods?
There's really two things that I would focus on here. One is just to file as early as possible. And then two would be to make sure you provide all of the required information up front. It used to be a common strategy in times past to just file what you had, and then you could wait for a request for evidence and submit the rest of the documentation then. It's just going to result in further delays. I wouldn't do that. The other thing, to file as early as possible, because USCIS really can't guarantee you any reasonable processing time. Even for premium processing cases, there are certain countries that are just not processing those. So filing as early as possible just gives you the best chance that you can get.
Now, for individuals considering changing jobs while their green card application is pending, what should they keep in mind?
Okay, this is a really big deal. I'm just going to give a high-level overview here. You are going to want to factor in something called portability. So there's two things you need to factor in. One, if you have filed for your adjustment of status already, your 485, you should try not to change jobs until your I-485 has been pending for at least 180 days. If it has, so 6 months that's been processing, then even if you have to leave your job, the one that did for the company that did your I-140 for you, you can still essentially get your green card as long as it's in a similar position in a similar company, right? That's really important for you to keep in mind. You also want to make sure you don't leave if you're in the middle of the perm process or before your I-140 is approved, because at that point, even if they've done the entire labor certification process, it would essentially be for nothing if you leave before that's completed.
All right. Now, attorney, looking ahead, what practical advice would you give applicants to plan effectively and stay proactive throughout the green card process?
This is self-serving, but I probably sit down with an attorney at least once and plan out your strategy. If you want to stay in the U.S. long term, you have to have a plan in place. You should have a plan for how you're going to legally live and work in the U.S. and how you plan to transition to permanent residence. I think a big thing that a lot of people don't plan on in their immigration journey is they sometimes don't factor in let's say, change in lifestyle or costs that come into play, or health insurance, or purchasing houses, right? Like, people make ties here while they're here studying or while they're here working. And I think that having a plan in place of how long you plan on staying or what you plan on doing is important to make sure you're not wasting your opportunities.
Yeah, yeah. Thank you for those insights, Attorney. Now, for everyone watching, this conversation about employment-based green cards is not meant to create concern, but to provide clarity around a complex and evolving process. Delays can be frustrating, but understanding how the system works and planning can help reduce uncertainty and support better decision making. Having accurate information allows individuals and employers to take proactive steps and to stay prepared. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration related questions at no cost and engage with participating attorneys. We're also proud to announce that ImmigrationQuestion.com is Triple B accredited and ISO certified. This is reflecting our commitment to transparency, accountability, community education, and security. Now, Attorney Jacob, based on your experience, how does immigrationquestion.com help immigrants and immigration attorneys like yourself?
I think it's an incredible resource. You have great access to essentially crowdsourced knowledge. I know everybody loves their favorite toy, ChatGPT or Claude right now, but a lot of times, I can't tell you how many times I've had clients or consults who will say, "Hey, I read this on ChatGPT told me this, I'm good to go," right? And ChatGPT failed to account for some factors on there. So at least with immigrationquestion.com, you've got people who actually do this on a daily basis to provide you this information at free or low cost, who have credibility as well.
Yeah. Yeah, thank you for those thoughts, Attorney. Now, before we move into our live Q&A, let's tackle this last important question. What are some common misconceptions about employment-based green cards and processing delays that you believe individuals should clarify early on to avoid misunderstandings?
Oh, that's a good one. I ask that very often. I'd say there's honestly a lot of misconceptions. I would say some of the ones that I find most problematic right now. One, transparently, are people who have friends who've been approved for certain processes in times past who don't realize that the government in place right now processes things quite differently than their friend may have in times past. So it's to understand that compliance with immigration law and compliance with the regulatory requirements is more important than ever now. Frankly, people who are denied for their non-immigrant status applications or their immigrant petitions, who don't maintain their status or who have other violations, are more often than not receiving notices to appear for deportation proceedings now. I don't say this to try and cause alarm, but essentially just to tell people, make sure you are well prepared when you apply and that you don't skip any necessary or important steps. It's not the best time to take unreasonable risk right now. So that's probably the biggest misconception, I would say.
All right. If you're just joining us, we've been speaking with Attorney Jacob Tuimaualuga, Jacob T, on employment-based green cards, understanding delays, and how to plan ahead. We are now moving into our live Q&A session. This is your opportunity to ask immigration-related questions and hear educational insight from a licensed immigration attorney. Please drop the questions in the chat or call us live at 516-703-3483, and we'll take as many as time permits. All right. First question. Why are employment-based green card applications taking so long to process right now?
Yeah. I'm going to give you my cynical view here. It's intentional by the U.S. government's part. And the reason that is there is a lot of political will to reduce both legal and illegal immigration. I'm going to say this second part, the other reason for significant delay for employment-based visas is also going to be very country specific. So there are certain countries right now where immigrant visas cannot be processed right now. For example, I work with a lot of clients from Nigeria who have approved EB2 national interest waivers or EB1A extraordinary ability petitions, even though they have proven that they have extraordinary or exceptional ability and they're going to provide these benefits to the US. The government abroad is just not processing their visas right now. You can have your interview, you can give them everything. They're not going to give you the visa until the government decides to remove this freeze that's in place. So that's a significant roadblock right now for employment-based green card processing.
All right. How do visa bulletin backlogs and priority dates affect when I can get my green card?
Yeah, they affect everything with getting your green card. So as I previously mentioned, the visa bulletin updates every month, and your priority date that's listed on your petition, so let's say your I-140 petition, will govern when you are able to file for adjustment of status and when your actual green card will be issued. So if you were to log on to, go to Google right now and look up visa bulletin for May 2026, you will find on chart A final action dates for the petitions for employment-based applications. That's the date that your I-140 needs to have or be before in order for USCIS to process your green card, right? So that's a super important thing to keep in mind. A lot of times you can use the chart B, which is dates for filing. There's a link on the visa bulletin. If you click that, it can tell you which is the right chart to use. So a lot of times you can use that and file adjustment of status even years before your actual green card can be issued. But just for you to keep in mind, until your date is on or earlier than the date on the final action, they're not going to give you your green card. I'm sorry to say.
No. Is there anything I can do to speed up my employment-based green card process?
Yeah, it's a good question, Carlos. It depends on what stage of the process that you're in. So if you are self-sponsoring for a green card, you can premium process the employment-based green card process by filing something called an I-907, and you can premium process the I-140 form, which is the employment-based immigrant petition, right? It costs right now, as of April 17th, I'm saying this, it's $2,965 to upgrade to premium processing. Outside of that, there's really not much else that you can do for your application. In some cases, if you have extraordinary circumstances, let's say you've already gotten that part approved. If you have extraordinary circumstances and you're waiting for your adjustment of status to be approved and your priority date has already come up on the final action in the visa bulletin, you could try and contact USCIS to explain your extraordinary circumstances or ask for congressional assistance, and they might process it more quickly. But just to be honest, this is kind of a Hail Mary. It's not likely for it to work, but you could try that as well.
Yeah. All right. What happens if my job changes or I lose my job while my green card application is still pending?
Yeah, this unfortunately is very common right now. There have been so many layoffs nationally, including at some of the country's biggest companies. It depends on what stage of the process you are when the layoff happens. If you get laid off during the labor certification phase, whether you're in the wage or the advertisements or during the labor certification pending, you are out of luck. You're gonna have to start that process over. If your I-140 has been approved and you are laid off, you might be able to maintain the priority date from that petition. So this would be really important if you were trying to apply for a different green card process or if you're applying for another labor certification. But if you try to change jobs, let's say you got approved last week and you get fired today, if you can't file for adjustment of status yet, you're going to have to go through this process again in all likelihood. But you can use your I-140 date, your priority date from your last I-140. Last part, I'm probably talking too long for this part, but for this last part, if you get laid off during the adjustment of status phase, if it's been 180 days, you can essentially maintain your green card petition. You're just going to need to have something called a 485 Supplement J signed by your new employer, and you need to be working in essentially the same position or very similar position in a similar company as well. There's a lot of nuance in it.
Yeah. All right. How can I plan my career and travel while waiting for my green card approval? Pardon me.
Sorry, I'm not sure if I quite heard the first part in there. How can you plan your career, you're saying?
How can I plan my career and travel while waiting for my green card approval?
Yeah, similar to last time, it kind of depends on what stage of the process that you are. If you have that pending, if let's say you have a green card application pending right now, if you have an H-1B or you have an L-1 visa, you have greater flexibility to travel internationally, even with your adjustment of status pending, assuming you still have your job for your H or your L, and that's still valid. You should be okay to travel internationally. I would check with an attorney your specific facts, but that's the general rule.
Yeah.
If you don't have an H-1B, you don't have an L visa, you can apply for something called advanced parole. You file something called an I-131 form with your adjustment of status, and it takes somewhere around 8 to 10 months right now to process, but you'll receive this travel document that will allow you to travel internationally. Sometimes it may not make sense for you to do this because it could affect your work authorization in the US if you don't have another work permit. Sometimes if you have an H-1B, it may not make sense to use this advanced parole document. The last thing, though, I will say as a word of caution, right now, it's probably best to avoid non-urgent international travel if you have a pending green card application, because transparently, there have been a lot of reports in a ton of different countries of consular officers causing great difficulty for visa applicants, or Customs and Border Protection officers here at American airports who are refusing entry or causing great difficulty at the time of entry as well. If I were you, I might consider deferring unless it's absolutely necessary until you have your card.
Yeah. Thanks for those insights. Now, Attorney, recent reports indicate that ICE has launched a new crackdown on alleged birth tourism networks. These developments reflect ongoing enforcement efforts and increased scrutiny in certain areas of immigration activity. Now, when individuals hear about enforcement actions like this, even if unrelated to employment-based immigration, how should they interpret these developments?
Yeah, this is a really interesting question. I would interpret this under the lens of increased immigration scrutiny across the board. As I previously mentioned, one of the hallmarks of the Trump administration's election and execution here in practice has been a greater restriction on immigration, obviously legal immigration, but also legal immigration. And I don't think you'd find anybody who could reasonably deny that. So the president has appointed a number of advisors and leaders at the Department of Homeland Security and in other governmental organizations that are increasingly focused on cracking down on what they perceive or what the public perceives as abuses of the immigration system. And one of those is this birth tourism. Essentially, the caricature that is painted is that applicants from abroad will come here at 8.5 months pregnant. They'll give birth and they will go back to their home country, and they will be just as American as anybody here in the States. And then they can vote and influence political elections forever, despite not being true Americans in the sense of the administration. So this is definitely a big emphasis. And I think if nothing else, it's just a reminder for employment-based immigrants to make sure everything's prepared as well as possible and that you avoid any appearance of evil or misconduct in misrepresentation, because this is, it's just increased scrutiny, and it's important to do things correctly.
Yeah. Thank you so much to everyone who joined this special edition webinar, and thank you, Attorney Tuimaualuga, for sharing your knowledge and practical guidance with us today. You can always visit immigrationquestion.com to ask immigration-related questions, stay informed about policy updates, and register for upcoming live events. If you missed any part of today's important discussion, the replay will be available on Spotify soon. Just search Borderless Talk by immigrationquestion.com. We look forward to seeing you on Wednesday for our next live session. Until then, stay informed, stay prepared, and stay connected. Bye-bye.
Thank you, Blessing. See you.
Thank you, Attorney.